We'll hear from the appellant.
Good morning. May it please the court. Joseph McMurray here on behalf of the plaintiff, Wendy Coram and Robert Coram. I am here with my co-counsel, Wayne Culbertson. Your Honors, if I could please just very briefly speak as to some of the facts in this matter. On October 21st, 2020, Ms. Coram actually went into surgery for
I'm sorry, did you want to reserve any time for rebuttal?
Oh, thank you. Thank you, Judge.
Thank you.
I apologize for that. If I could reserve 5 minutes.
That'll be fine. Thank you.
Thank you. I can't make it through a day without making at least one mistake. Ms. Coram actually went in on October 21st, 2020 for surgery to her L3 vertebrae. The day later, she complained of pain radiating down her leg and weakness. She stayed in the hospital until October 24th, 2020, when finally treating physicians performed surgery on Ms. Coram, but unfortunately it was too late. And Ms. Coram today suffers from pain and partial paralysis to her leg. On September 7th, 2021, so this was in October of 2020, September 7th of 2021, plaintiffs submitted and sent their pre-suit notice in this matter. Okay? That was the first pre-suit notice. 52 days later, plaintiffs actually submitted another HIPAA request. HIPAA authorization. The difference between those two HIPAAs contained in the first pre-suit notice and the second was a clerical error of the date of birth. In the first, the date of birth read 1971. Okay? Ms. Coram's date of birth is actually 1977. So 52 days later, on October 29th, 2021, plaintiffs actually submitted to all defendants a second HIPAA that had that correction. After 53 days, plaintiffs actually filed their complaint, at which time the defense filed their motion to dismiss, and we are here before. Your Honors, I would submit into the court that there are 3 reasons why the trial court actually was in error in this matter. The first being is that the initial HIPAA actually complied with all of the 6 core elements. And what are those 6 core elements? If you look at 45 CFR 164.508, those 6 core elements are listed, and important for the court is 1I2, which is the name or other specific identification of the persons. So the only thing that the plaintiff was required to submit to defense in the HIPAA was the name or other specific identification of the persons. And interestingly enough, that same language is used as far as the recipients of that HIPAA request. You have to provide their name or other specific identification of those persons. Nowhere listed in 45 CFR 164.508 or any of those 6 core elements is the requirement that there is a date of birth that we must give. We gave the name, we gave the social security number. I would submit to the court that I would say there are many individuals that have gone through the defense's hospital with the same date of birth. But there's only one individual that has the social security number. There's only one individual that has that specific social security number. And if the court is inclined to adopt the rationale from the defense, that would mean that the plaintiff would be obligated not only to provide the date of birth for the patient, but also to the doctor, the nurses, the people that we are disclosing this HIPAA to. because the same language that of the patient is the same way that we have to describe the recipients of the HIPAA. So for those reasons, there is not an exact and specific violation of any of the 6 core elements of the HIPAA in this case. But be that as it may, I know that these cases have been before the court several times, and the plaintiff need only substantially comply with 29-26-121. Need only substantially comply with the pre-suit notice requirements. And germane to that issue of whether or not the plaintiffs actually substantially complied with the pre-suit notice requirement is the issue of prejudice. Prejudice specifically to the defense. We received a lot of clarification in the Tennessee Supreme Court's decision in Martin v. Rolling Hills. And once the defense provides a prima facie case of a defect in the pre-suit notice requirements, it is then the obligation of the plaintiff to prove that the defense was not prejudiced. First, I don't think that there's any violation in the first HIPAA that we provided. It doesn't violate any of the 6 core elements. But second, as to the issue of prejudice, we supplied to the court in our motion to dismiss, we supplied an affidavit as well as a release. And as to the latter, I'd like to speak just very briefly on that. What that release is upon entry into Ballad Health, every patient must sign a release. This release states in part, I can have 1 second. Ballad Health and attending physicians are authorized to release medical records to any party, which includes agents or representatives of such parties. And the defendants may use, or Ballad Health may use, this release for the evaluation of services rendered by these providers. I would submit into the court that given this release that all patients must sign, the defense they were equipped with the opportunity to evaluate this case, which is germane. That is the issue at heart with the pre-suit notice requirement. Can the defense actually evaluate the case?
But is the question, can they evaluate the case with whatever extraneous information they may have, or is it, can they evaluate the case with the required information under the pre-suit notice and the HIPAA release?
Okay. Ultimately, the question would be, was the defendant in any way prejudiced by this clerical error on the first HIPAA? Okay? So first, we want to say, well, it doesn't violate any of the 6 core elements. Second, I don't believe there was any prejudice. If they had in their own records this release, an ability to evaluate the services rendered, which was located at Ballad Health, performed by doctors at Ballad Health, I don't think that there could be any way they were prejudiced. How they lacked the capacity or lacked the authorization to actually evaluate the necessary documents in this case.
Are you saying they had access to all the documents that were there?
I am saying that this release obviously gives them access to evaluate the services rendered by the providers.
Well, my question is a little more specific. Are you saying that release gives them access to all the documents, medical documents that were
germane to this case? Yes.
Yeah.
Yes, Your Honor.
All the medical documents of any of the named defendants?
Yes, Your Honor.
Okay.
Okay.
Let me ask you this, back to the core requirements. Moving beyond the 6, I think, that are stated in the CFR, Your opposing counsel is saying that another section of the CFR applies, and that section says that the release is not valid if it contains materially false information known by the covered entity to be false. So they're saying the wrong birth date equates to materially false information, and therefore, even though you put the name on there, it's still not valid. What's your response to that?
My response to that would be, I actually looked up in Black's Law Dictionary the term false. I know it's a term we use pretty routinely. But the term false, according to the Black's Law Dictionary, is untrue, erroneous, deceitful, contrived, or calculated to deceive. This word means something more than untrue. It means something designed untrue and deceitful. There's two issues with that argument, Your Honor. First, it had to have been known to be false by the defendant. Okay, they've got a pre-suit notice, and in the first page of the pre-suit notice, there was the correct birth date. The HIPAA had the incorrect birth date. How did they know which birth date was false? Second, there's not any allegation that this was created with any kind of intent to deceive. I don't think it meets the qualification of false. I think that's a loaded term. It means something more than just an error. I think it means something that was intentionally false and that the defendants actually knew that it was made with some deceit.
You've used your time.
Oh, okay.
You have your time for rebuttal. Hear from the appellees.
Good morning. May it please the court. I'm Meredith Humbert of the Sullivan County Bar, and along with my partner, Jimmy Miller, we represent the appellees, Ralph Figg, Dr. Yoshi, Dr. Patrick, and their medical practice, Ballad Health Medical Associates Family Medicine. I just realized I'm making the same mistake that Mr. McMurray did. I would like to reserve 4 minutes for Mr. Adkins.
I was going to remember to ask this time.
Thank you.
So you have 11 minutes, and then it'll be 4 minutes.
Thank you. At the request of Mr. Anderson, I am also arguing on behalf of his clients, and that's Ballad Health and Bristol Regional Medical Center. This trial court in this matter properly dismissed the appellant's complaint for their failure to substantially comply with the pre-suit notice requirements of Tennessee's Healthcare Liability Act by providing the appellees with a defective medical authorization. In this matter, it is not disputed that appellant Wendy Campbell's date of birth was incorrect on the medical authorization that was sent with the notice of intent letter to the appellees on September the 7th of 2021. Including an incorrect date of birth meant that the appellants did not substantially comply with the statutory requirements when they sent the original notice of intent because the authorization was defective. Case law in Tennessee is clear that substantial compliance can't be established when a defective medical authorization is provided to multiple providers pre-suit. This is obviously a case where not all of the physicians are at one medical practice. We have multiple defendants, a neurosurgeon, hospitalist, and then a hospital system.
Are all the records of those defendants in one place?
Your Honor, they may have been in the electronic health record for the medical system that serves the entire Tri-Cities and Southwest Virginia area. But having login information for an electronic health record does not equate to having a permissible use to access medical records under HIPAA.
All right, my question, what I should have asked, was were all the medical records in one place and available to all the defendants?
And Your Honor, I believe that would not be true in this case because the neurosurgeon's office would have seen the patient outside of just this hospitalization. There was a first surgery, the patient went home and then returned to the hospital. There also would have been clinic records for that neurosurgeon as part of the workup for surgery.
Just at the neurosurgeon's office?
Correct.
Okay.
Let me ask you this, because to me this case kind of turns on this particular issue. You've got the 6 core requirements of the CFR, which do not include a requirement of date of birth. Do we all agree on that?
Yes, Your Honor.
So you could put the name or other identifying information. There's no question they had the name.
Well, what's interesting is actually when we talk about the names under the core elements, it's not the patient's name. It's the name of the providers authorized to release the information, and it's the name of the individual or provider authorized to receive it. So I read it and reread it. The name of the patient is not a core element, which was why it's a great example of something that's material information.
Well, in this case, though, it was her name that was used as the authorized person to make the requested use.
Correct.
Okay.
And of course, I think everybody would agree that a name should be included in a medical authorization.
So then
However,
we move to your second argument,
Yes.
which is the providing of false information. And what do you say to counsel's argument that the requirement of false information requires some sort of scienter or more than just a Scrivener's error or a common mistake?
Yes. So I like Mr. McMurray. He looked up Black Law's dictionary on his phone. I actually got the book out, which I know a lot of lawyers of my generation don't do, but I did that. First, I had hit a wall looking online, I'll admit. But I looked up, instead of false, I looked up what does material mean? Because it's really defective and not false. That's the word that matters. And so when I looked up material, and I was using the 4th edition, it described it as being important, more or less necessary, having influence. So not all that helpful. I mean, I think it's material, a social security number, a date of birth, a name. But then I went down, and under material was an entry for material alteration. And I thought that was relevant since a medical authorization is something we think of as, you can't alter it. And so a material alteration was defined as being an alteration when the legal effect thereof is changed, notwithstanding the triviality of the change. In this case, that definition fits because the appellants attempt to convince the court that the incorrect date of birth was just a clerical error. But by including an incorrect date of birth, it's more like including an incorrect social security number, an incorrect name, because it does change the legal effect of the medical authorization. Of significance, I think the appellant's brief did not address the issue of what is defined as being defective under the regulations that govern HIPAA compliance.
I don't think either one of you all cited cases specific to that issue. I'm going to assume you all found none.
As to what's material
or false
or false
under that section of the CFR.
They did not include a definition for defective or false in the CFR, which is probably how we both ended up at Black's Law Dictionary. I think it goes to the appellant's argument, and they put this a couple of places in their brief, that they had the social security number right. But in order for a date of birth and social security number, those are similar material pieces of information for a person. When I think of material information, I think about information for a person that you can't change without some type of maybe government involvement. Maybe a driver's license would be a driver's license number would be another example.
Did it have to be material information that the covered entities knew to be false?
Correct. And I think
how would they know that her birthday was false unless unless they actually knew her birthday?
Well, I think by the virtue of the fact that it was written as 2 different years in the same mailing, while I know that the court has said that you're not supposed to, you can't use notice of intent letters to cure defects.
Plaintiffs can't use that to their benefit. So.
Right. But it was certainly a heads up to the providers that something's not right.
Okay. So you knew the birthday was wrong.
Yes, we were aware of that, which is what
you have to. That has to be your position.
Yes.
For that other. Okay.
Yes. That
so we knew the birthday was wrong.
Right. We knew it was wrong. We were not under an obligation to test it. I want to address the issue of prejudice briefly.
Well, I'm going to ask you some more
sure.
questions
Okay.
here, though.
I'm sorry.
You've raised something I think has always puzzled me here. 2 and 3 under the 45 CFR 164, so forth. They don't talk about, do they, the name or the identifying information of the patient? Is that right?
That's correct, Your Honor.
So the core element, the 6 core elements don't include identifying the patient specifically.
Yes, it's hard to believe that our United States legislature, or the body that enacted this regulation, drafted it this way, but I agree
Or
with that.
maybe it's not
Yeah, it's not that hard to believe.
hard to believe.
Okay.
Yeah. Okay,
I don't disagree with
the identifying of the patient is not one of the 6 core elements.
No, but it's obviously an example of material information, and I think that if you left the name off, we would have a similar argument like we have here today, that that's a piece of material information, and by leaving it off, it makes the authorization become defective. I could address the issue of prejudice just for a minute. Is that
Sure,
okay?
of course, yes, thank you for answering the question.
So during the hearing that the trial court had back on September the 15th of 2022, the trial court correctly concluded that the appellant's notice did not comply with the statute 121 because the authorization did not provide the appellees with the means to obtain complete copies of Wendy Coram's medical records from the other providers who received the notice. And that was on page 13 of the hearing transcript. In Stevens, the Tennessee Supreme Court determined that the purpose of Section 121 is to equip the defendants with the actual means to evaluate the substantive merits of a plaintiff's claim by enabling early access to the medical records. The court went on to say that it's a threshold requirement of the statute that the plaintiff's medical authorization must be sufficient to enable the defendants to obtain and review a plaintiff's medical record. The judge was correct. The trial court judge, Judge McClellan, correctly ruled that we weren't able to do that, and because of that, we were prejudiced. In Martin, which was a 2020 decision, the Supreme Court held that the defendants don't have to test a non-compliant medical authorization. So we weren't under a burden to test it or try to see if Dr. Brasfield's office would ignore that date of birth and give us the records. We talked briefly, the appellant's counsel mentioned the affidavit, and that was an affidavit by a mid-level provider, Casey Johnson. That affidavit does not establish a lack of prejudice to the appellees. Rather, the affidavit states that each of the individual medical providers who were named as defendants had login information for the system's EHR. They did. Everybody that has hospital privileges has login information. A login ability does not equate to a permissible use under HIPAA. I also want to address their argument that the second notice of intent would somehow relate back to the date when the original notice of intent was provided. You know, relation back is governed by Tennessee Rule of Civil Procedure 15, and this court's been clear that a pre-suit notice letter is not a pleading. I think that was the holding in Carrasco, Shockley, Carter, so we think that the law is well settled on that point, that you can't relate back the second notice to the original one.
Your time is up, but I have one question I want to ask before you sit down. It's a hypothetical. Let's assume that they had sent the HIPAA authorization with just the name, no birth date at all, no social security. Would that be in compliance with the core elements?
Your Honor, I think that if it had each of the core elements that required statements under another section, that they did not have to include the date of birth for it to be HIPAA compliant. But by choosing to include it and by getting it wrong, it became defective because the date of birth material information. Thank you for the opportunity to present our client's argument today.
Thank you. Hear from you, sir.
May it please the court, I'm Russell Adkins of the Sullivan County Bar. I'm here on behalf of the defendants, Dr. James Brasfield and Mark Melferber, PAC. They are not part of or related in any way to any of the legal entities who are co-defendants in this case. They are a freestanding practice that treated Ms. Coram. So the treatment at issue took place at the hospital, and the effect of this was that Dr. Brasfield and Mr. Melferber were deprived of access to the hospital records that were needed to evaluate this case. And the Supreme Court has told us in the Stevens case that that's really what's important. Does the authorization give the providers the opportunity to access that information? Under the HIPAA regulations that have been discussed this morning, the first question is, was the information false? And I would urge the court to just use ordinary meaning of the language if false means not true. It means wrong. I don't think there's any question that the information was wrong. Anywhere except in a lawyer's office, that's what it means. And did the providers know that it was wrong? Well, Dr. Brasfield and Mr. Melferber treated her. They had their own records. They had her date of birth, so they knew what was the correct date of birth, and it was clear that this was not it. So in Stevens and Martin, the Supreme Court has emphasized that the penalty imposed upon providers who either request or provide information pursuant to a defective authorization have steep penalties. And the Supreme Court has pointed out that the penalties can be up to $50,000 per offense and or imprisonment up to 1 year. So it's understandable why a provider would want to tread very lightly before either requesting or releasing records if there's any question about the validity of a HIPAA authorization. The pre-suit notice provisions just should not be allowed to put a provider into that position where they have to choose between exercising their rights to get the information or risking enforcement action from the federal government. So this case is time barred. The trial court acted properly in granting dismissal, and I ask that the lower court's ruling be affirmed.
Thank you. Hear from the appellant rebuttal.
Thank you. First, if I could just speak to the affidavit that we provided. This affidavit was submitted on behalf of the plaintiffs by Casey Johnson, PA, who had worked for Ballad Health for quite some time, and he was familiar with the medical documentation and the storage. And Mr. Johnson stated in this affidavit that any medical provider with privileges would have access to all the records at Bristol Regional Medical Center, which is under the umbrella of Ballad Health, and to the records generated as to the treatment of their patients. So those records that they actually performed the surgery at Ballad Health. Now, Chief Judge actually asked me, do you believe that all the records at one entity? We do believe that. We asked for discovery on that issue, and we were denied the ability to actually conduct the discovery on that one issue, Your Honor. So I was operating on information and belief. I didn't want you to think that I misspoke in any way, but that is the plaintiff's position, and that's what we believe, because everything that was done that's germane to this case happened at Bristol Regional Medical Center, which is under the umbrella of Ballad Health. And so these physicians actually performed the surgery there. So, and other than that, as to Mr. Atkins' statement about the plain meaning of false, and believe me, I don't think we should doubt in law what we don't doubt in reality. I don't. But I do think that terms do have a specific meaning. And the plaintiffs are obligated, I would say almost to a fault in these pre-suit notice and healthcare liability actions, to follow the letter of the law. And I think that we have to give the exact meaning to the term false. And what does it mean, according to the Black's Law Dictionary? And it does mean some intent to deceive. So I don't believe that there was any violation of the 6 core elements. That's all we were required to do. We're trying to get to the merits of the case. And all we're required to do is provide a HIPAA that actually didn't violate any of these core elements, and I believe we did. Now, with our supplemental, with the release, which I believe is synonymous to a HIPAA release, as well as our affidavit, I think that we have undermined the defense argument as to prejudice, how they were prejudiced in this situation. They were equipped with the opportunity to evaluate, to tell us, despite what her birth date was, and even though we didn't even have to include it, but we did. We included a social security number. They had the materials on hand to evaluate this case and to determine if it was something that they could try to resolve prior to filing a complaint. Did not happen here. Did not happen here. We provided a second HIPAA. We waited longer. And then we filed our complaint wanting for Ms. Coram and her husband to have their day in court. And unfortunately, we are here today. And Judge, I believe that, just to reiterate, I believe we've got a good HIPAA here. It doesn't violate the core elements. Is it perfect? We're not required to be perfect. Substantial compliance means something. It's not strict compliance. It's substantial compliance. We can't prejudice the defense. And I don't think we did that in this case. I think that we have, once that burden shifted, according to Martin v. Rolling Hills, once that burden shifted back to us, we provided the necessary documentations by affidavits, by the release that we show, which is very synonymous to a HIPAA release, that there wasn't prejudice on the defense side. So I could agree with opposing counsel as to the definition of materiality. I can agree with that. But it's that term false. And words are stubborn things. Definition are stubborn things. And we're held to the definitions of included in 2926-121 to a T. And I believe that the exact and strict reading of the definitions of 45 CFR should be given the same weight. Thank you. If there's any questions.
I hear none. Of course, thanks to counsel for both sides. We appreciate your oral arguments this morning and your briefs. If you would, please recess